Here is how the lies start. My position of late on going to court has always been never voluntarily go to court. Alive men and women are not meant to be in any place designed solely for the business of fictional entities. When we attend court, we are deemed dead. In fact, they cannot deal with us until we admit to being dead, a legal fiction, a trust. Court is for titled persons, judge, prosecutor, defendant, bailiffs, cops, and attorneys. Alive men and women are not recognised, so it makes sense to send in a dead person, an attorney, to handle our cases. Except for one thing, they do not know how the system works due to their indoctrination. If you can find one to do as you say, then you will prevail, but most of them would rather hang onto their bar cards than behave honourably. The only thing that dead, fictional entities want from us is our life energy, and the only way they can get it is by our agreement. Without us, they cannot function. So they are desperate to get us into court to have us pay the debt which they created by charging the trust. Since common law courts no longer exist, we know that the case never has anything to do with facts or alive men and women, and so anyone who testifies, talks about the facts of the case, is doomed. All courts operate in trust law, based upon ecclesiastical canon law, ritualism, superstition, Satanism, etc., which manifests as insidious commercial law, and we are in court to take the hit if they can get us to do so. They use every trick in the book: intimidation, fear, threat, ridicule, rage, and even recesses in order to change the jurisdiction when they know they are losing, in order to make us admit that we are the name of the trust. When we do so, we are deemed to be the trustee, the one liable for administering the trust. Ergo, until now, it has been a waste of our time, energy, and emotion to go to a place where it is almost certain that we will be stuck with the liability. We all know from our indoctrination, programming, and schooling that judges are impartial and have sworn an oath to this effect. This means he must not favour either plaintiff or defendant, but our experience reveals that he does indeed favour the plaintiff, indicating a glaring conflict of interest that the prosecutor, judge, and clerk all work for the state, the owner of the CQV trust. So, as the case is not about justice, it must be about the administration of a trust. They all represent the trust owned by the state, and if we are beneficiary, the only two positions left are trustee and executor. So if you detect the judge's partiality, although I doubt the case will get this far, you might just want to let them know that you know this. If you consider court as entertainment, and if you can stand the evil emanating from its officers, the fear and angst oozing from the walls, and the treacherous atmosphere, then go, knowing that under trust law, we cannot be the trustee or the executor of a trust, whilst being beneficiary, as that would be a conflict. The position of beneficiary may lack clout, but the other positions hold liability. Since state employees want to be the beneficiaries of the trust, the only way they can do so is to transfer to us the liability which they hold as trustees and executors, because they also cannot be both the administrators and beneficiary of the trust. So, trusteeship and executorship, i.e. suretyship, becomes a hot potato, and everyone wants to toss it so he or she can be beneficiary of the credit from the trust. When we were born, a trust called a Chestui KV Trust, or CQV, was set up for our benefit. Evidence of this is the birth certificate. But what is the value which must be conveyed to the trust in order to create it? It was our right to property via birth into this world, our body via the live birth record, and our souls via baptism. Since the state or province which registered the trust is the owner, it is also the trustee, the one that administers the trust. Since they also wanted to be the beneficiary of this trust, they had to come up with ways to get us as the beneficiary to authorize their charging the trust, allegedly for our benefit, via our signature on a document, citation, application, etc., then temporarily transfer trusteeship to us during the brief time that they want to be the beneficiary of a particular constructive trust. This means that a trust can be established anywhere, anytime, and the parties of the trust are quickly, albeit temporarily, put into place. But since a beneficiary cannot charge a trust, only a trustee can do so. It is the state that charges the trust, but they do so for their benefit, not ours. Albeit occasionally, we do reap some benefit from that charge, but nowhere near the value which they reap. Think bank loan. We reap a minute percentage of what they gain from our authorization. So the only way under trust law for them to be able to charge the trust is to get the authorization from the beneficiary, us, and the only way for them to benefit from their charge is to get us to switch roles from beneficiary to trustee, the one responsible for the accounting, and for them to switch their role from trustee to beneficiary, because no party can be both at the same time within the same constructive trust. They must somehow trick us into accepting the role of trustee. Why would we do so when the trust is for our benefit? And how do they manage to do this? Well, the best way is to get us into court and trick us into unwittingly doing so. But if we know what has transpired prior to our being there, it is easy to know what to say so that this doesn't happen. The court clerk is the hotshot, even though it appears as if the judge is. The clerk is the trustee for the CQV owned by the state or province, and it is they who are responsible for appointing the trustee and the executor for a constructive trust, that particular court case. So they appoint the judge as trustee, the one to administer the trust, and appoint the prosecutor as executor of the trust. The executor is ultimately liable for the charge because it was they who brought the case into court, creating the constructive trust on behalf of the state or province which charged the CQV trust. Only an executor or prosecutor can initiate or create a constructive trust, and we all know the maxim of law. Whoever creates the controversy holds the liability, and whoever holds the liability must provide the remedy. This is why all attorneys are mandated to bring their checkbooks to court, because if it all goes wrong for them, meaning either they fail to transfer their liability onto the alleged defendant, or the alleged defendant does not accept their offer of liability, then someone has to credit the trust account in order to offset the debt. Since the prosecutor is the one who issues bogus paper and charges the trust, it is the prosecutor or executor, the PE, who is in the hot seat. When the name of the trust, for example, John Doe, is called by the judge, aka administrator, aka trustee, the JT, we can stand and ask, are you saying that the trust which you are now administrating is the John Doe trust? This establishes that we know that the name is a trust, not a live man. What's the JAT's first question? What's your name? Or state your name for the record. We must be very careful not to identify with the name of the trust, because doing so makes us the trustee. What does this tell you about the judge? If we know that the judge is the trustee, then we also know that the judge is the name, but only for this particular constructive trust. Now think about all the times that JATs have become so frustrated by our refusal to admit to being the name that they issue a warrant, and then, as soon as the man leaves, he is arrested. How idiotic is that? They must feel foolish for saying John Doe is not in court, so I'm issuing a warrant for his arrest, and then the man whom they just admitted is not there is arrested because he is there. Their desperation makes them insane. They must get us to admit to being the name, or they pay, and we must not accept their coercion, or we pay. Because the JAT is the trustee, a precarious position, the best thing to say in that case is John Doe is indeed in the court. Point to the jat. It is you. As trustee, you are John Doe. Today, aren't you? During their frustration over our not admitting to being a trust name, the trustee and or executor of the trust, we ought to ask who they are. Before we go any further, I need to know who you are. Address the clerk of the court, the trustee for the CQV trust owned by the state or province. Are you the CQV's trustee who has appointed this judge as administrator and trustee of the constructive trust case number 1, 2, 3, 4, 5? Did you also appoint the prosecutor as executor of this constructive trust? Then point to the jat. So you are the trustee. Then point to the prosecutor, and you are the executor, and I'm the beneficiary. So now we know who's who, and as beneficiary, I authorize you to handle the accounting and dissolve this constructive trust. I now claim my body, so I'm collapsing the CQV trust which you have charged, as there is no value in it. You have committed fraud against all laws. Likely, we will not get that far before the jats will order case dismissed, or even more likely, the PE, as he clings tightly to his checkbook, will call, we withdraw the charges. We have exposed their fraud of the CQV trust, which exists only on presumptions. The CQV has no corpus, no property, ergo, no value. Trusts are created only upon the conveyance of property and can exist only as long as there is value in the trust. But there is no value in the CQV trust, yet they continue to charge the trust. That is fraud. The alleged property is we men and women whom they have deemed to be incompetent, dead, abandoned, lost, bankrupts, or minors. But that is an illusion. So if we claim our body, then we collapse the presumption that the trust has value. They are operating in fraud, something we've always known, but now we know how they do it. Our having exposed their fraud gives them only 3 options. 1, they can dissolve the CQV trust, the one for which the clerk of the court is trustee and from which they created a constructive trust, the case for which they appointed the judge and prosecutor titles which hold temporary liability, trustee and executor, respectively. But they cannot dissolve the CQV, or the entire global system will collapse, because they cannot exist without our energy, which they obtain via that CQV trust. 2, they can enforce the existing rules of trust law, which means, as trustee, they can set off their debt and leave us alone. Now they know that we are onto their fraud, and every time they go into court to administer a trust account, they will not know if we are the one who will send them to jail. The trustee, the judge, is the liable party who will go to jail, and the executor, the prosecutor, is the one who enforces this. This is why they want us to take on both titles, because then not only do we go to jail, but also by signing their paper we become executor and enforce our own sentence. They cannot afford to violate the Ecclesiastical Canon laws out of fear of ending their careers, so they are, again, trapped with no place to run. 3, they can dismiss the cases before they even take the risk of our exposing their fraud, which also makes no sense, because then their careers again come to a screeching halt. What's a court clerk to do? Pretty soon, none of these thugs will take any cases because the risk is too great. This will be the end of the court system. Knowledge, not procedure, is power. The means by which we have attempted to assuage our problems, inflicted upon us by the PTW, powers that were, have all been superficial compared to the origins of all the black magic, superstition, satanic ritualism, trickery, mind control, and clandestine practices. Under commercial law, dating back to the Code of Ur-Nammu around 2100 BCE, the use of another's property without permission puts one into dishonour and makes him liable for any debts. So, are using UCC forms, bills of exchange, AFV, or bonds, and altering documents of the Roman system can create penalties. as this is trading and/or using the property of a corporation we do not own. The birth certificate proves that the name is, in fact, the property of the corporation which issued it. We can do all the paper perfectly, but in the end they say, sorry, you're not one of us. But now we get to inflict fear onto them. When we are forced to court, knowing that the judge acts as the trustee and the prosecutor acts as executor of the CQV trusts is empowering. It gives us two choices. One, if we wish to expose the fraud of presumptions by which the CQV trusts still exist, then the court is the perfect opportunity to have them dissolved or to prove the fraud because the trustee is sitting on the bench. Dissolving the first CQV dissolves them all, or two. If we are not inclined to use something like the Ecclesiastical deed poll to expose the fraud of the CQV trusts, then at least we ought to know that everything the judge says, even if it sounds like a command, order, or sentence, is actually an offer which we can choose to decline. I do not consent. I do not accept your offer. This is a fundamental principle of testamentary trusts. The beneficiary can accept or decline what the trustee offers. For 15 years, I have watched the alleged solutions in commerce come and go, and nothing has worked for enough people on enough occasions to call anything a consistent win. Paying for information is insanity because those who sell information clearly have not prevailed, or they wouldn't need to sell anything, would they? Buying express private contract trusts, for example, NACRs, is a huge waste of time and money because the entire process is too complicated for anyone with an IQ below 400 and no refunds. I have found no solution in commerce because those who claim to have solutions still insist upon treating symptoms rather than curing the cause, the fraudulent CQV trust. The first trust of the world. Unam Sanctam is one of the most frightening documents of history and the one most quoted as the primary document of the popes claiming their global power. It is an express trust deed. The last line reads, "Furthermore, we declare, we proclaim, we define that it is absolutely necessary for salvation that every human creature be subject to the Roman Pontiff. It is not only the first trust deed in history, but also the largest trust ever conceived, as it claims the whole planet and everything on it conveyed in trust. Triple Crown of Baal, also known as the Papal Tiara and Triregnum." In 1302, Pope Boniface issued his infamous papal bull Unam Sanctam, the first express trust. He claimed control over the whole planet, which made him king of the world. In celebration, he commissioned a gold-plated headdress in the shape of a pine cone with an elaborate crown at its base. The pine cone is an ancient symbol of fertility and one traditionally associated with Baal as well as the cult of Cybele. It also represents the pineal gland in the center of our brains, crystalline in nature, which allows us access to source, hence the 13-foot tall pine cone in Vatican Square. Think about why the pontiffs would idolize a pine cone. See, Pharmacratic Inquisition, the first crown of Crown Land. Pope Boniface VIII was the first leader in history to create the concept of a trust, but the first testamentary trust, through a deed and will, creating a deceased estate, was created by Pope Nicholas V in 1455, through the papal bull Romanus Pontifex. This is only one of 3 papal bulls to include the line with the incipit for a perpetual remembrance. This bull had the effect of conveying the right of use of the land as real property, from the express trust Unam Sanctam to the control of the pontiff and his successors in perpetuity. Hence, all land is claimed as crown land. This first crown is represented by the first Gestuike V trust, created when a child is born. It deprives us of all beneficial entitlements and rights on the land. The second crown of the Commonwealth. The second crown was created in 1481 with the papal bull Aeterni Regis, meaning eternal crown, by Sixtus IV, being only the second of 3 papal bulls as deeds of testamentary trusts. This papal bull created the crown of Aragon, later known as the crown of Spain, and is the highest sovereign and highest steward of all Roman slaves, subject to the rule of the Roman pontiff. Spain lost the crown in 1604 when it was granted to King James of England by Pope Paul V after the successful passage of the Union of Crowns, or Commonwealth, in 1605 after the false flag operation of the Gunpowder Plot. The crown was finally lost by England in 1975 when it was returned to Spain and King Carlos I, where it remains to this day. This second crown is represented by the second Cestui V trust, created when a child is born, and by the sale of the birth certificate as a bond to the private central bank of the nation, depriving us of ownership of our flesh and condemning us to perpetual servitude as a Roman person or slave. The third crown was created in 1537 by Paul III through the papal bull convocation, also meant to open the Council of Trent. It is the third and final testamentary deed and will of a testamentary trust set up for the claiming of all lost souls lost to the sea. The Venetians assisted in the creation of the first Cestui V Act of 1540 to use this papal bull as the basis of ecclesiastical authority of Henry VIII. This crown was secretly granted to England in the collection and reaping of lost souls. The crown was lost in 1816 due to the deliberate bankruptcy of England and granted to the Temple Bar, which became known as the Crown Bar, or simply the Crown. The bar associations have since been responsible for administering the reaping of the souls of the lost and damned, including the registration and collection of baptismal certificates representing the souls collected by the Vatican and stored in its vaults. This third crown is represented by the third Cestui V Trust, created when a child is baptized. It is the parent's grant of the baptismal certificate, title to the soul, to the church or registrar. Thus, without legal title over one's own soul, we will be denied legal standing and will be treated as things, cargo without souls, upon which the bar is now legally able to enforce maritime law. A Cestui V trust is a fictional concept. It is a temporary testamentary trust, first created during the reign of Henry VIII of England through the Cestui V Act of 1540 and updated by Charles II through the CQV Act of 1666, wherein an estate may be effected for the benefit of a person presumed lost or abandoned at sea and therefore assumed dead after 7 years. Additional presumptions by which such a trust may be formed were added in later statutes to include bankrupts, minors, incompetents, mortgages and private companies. The original purpose of a CQV trust was to form a temporary estate for the benefit of another, because some event, state of affairs, or condition prevented them from claiming their status as living, competent, and present before a competent authority. Therefore, any claims, history, statutes, or arguments that deviate in terms of the origin and function of a CQV trust, as pronounced by these canons, is false and automatically null and void. A beneficiary under estate may be either a beneficiary or a CQV trust. When a beneficiary loses direct benefit of any property of the higher estate placed in a CQV trust on his behalf, he does not own the CQV trust. He is only the beneficiary of what the trustees of the CQV trust choose to provide. As all CQV trusts are created on presumption, based upon original purpose and function, such a trust cannot be created if these presumptions can be proven not to exist. Since 1933, when a child is born in estate, under inferior Roman law, 3 cestui trusts are created upon certain presumptions specifically designed to deny forever the child any rights of real property, any rights to be free, and any rights to be known as man or woman rather than a creature or animal, by claiming and possessing their soul or spirit. The executors or administrators of the higher estate willingly and knowingly: 1. Convey the beneficial entitlements of the child as beneficiary into the first cestuique v trust in the form of a registry number by registering the name, thereby also creating the corporate person and denying the child any rights to real property. And 2. Claim the baby as chattel to the estate. The slave baby contract is then created by honouring the ancient tradition of either having the ink impression of the baby's feet onto the live birth record or a drop of its blood, as well as tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record, which is a promissory note converted into a slave bond, sold to the private reserve bank of the estate, and then conveyed into a second and separate CQV trust per child, owned by the bank. When the promissory note reaches maturity and the bank is unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and is monetized as currency issued in series against the CQV trust. 3. Claim the child's soul via the baptismal certificate. Since 1540 and the creation of the first CQV Act, deriving its power from the papal bull of Roman cult leader Pope Paul III, 1540, when a child is baptized and a baptismal certificate is issued, the parents have gifted, granted, and conveyed the soul of the baby to a third CQV trust owned by Roman cult, which has held this valuable property in its vaults ever since. Since 1815, this third crown of the Roman cult and third CQV trust representing ecclesiastical property has been managed by the BAR as the reconstituted gala responsible as grim reapers for reaping the souls. Each CQV trust, created since 1933, represents one of the 3 crowns representing the 3 claims of property of the Roman cult: real property on earth, personal property, body, and ecclesiastical property, soul. Each corresponds exactly to the 3 forms of law available to the gala of the bar courts: corporate commercial law, judge is the landlord; maritime and canon law, judge is the banker; and Talmudic law, judge is the priest. Given what has been revealed about the foundations of Roman law, what is the real hidden power of a judge when we face court? Is it their superior knowledge of process and procedure or of magic? Or is it something simpler and far more obvious? It is unfortunate that much of the excitement about estates and executors has deliberately not revealed that an estate, by definition, has to belong to a trust. To be specific, a testamentary trust or CQV trust. When we receive legal paper or have to appear in court, it is these same CQV trusts which have our rights converted into the property contained within them. Instead of being the trustee or the executor or administrator, we are merely the beneficiary of each CQV trust, granted only beneficial and equitable use of certain property, never legal title. So, if the Roman legal system assumes we are merely the beneficiary of these CQV trusts, when we go to court, who represents the trustee and office of executor? We all know that all cases are based upon the judge's discretion, which often defies procedures, statutes, and maxims of law. Well, they are doing what any trustee or executor administering a trust in the presence of the beneficiary can do under Roman law, and all the statutes, maxims, and procedures are really for show, because under the principles of trust law, as first formed by the Roman cult, a trustee has a wide latitude including the ability to correct any procedural mistakes by obtaining the implied or tacit consent of the beneficiary to obviate any mistakes. The judge is the real and legal name. The judge is the trust itself. We are the mirror image to them, the ghost, the dead. It is high sorcery, trickery and subterfuge that has remained legal for far too long. Spread the word. The first trust of the world, Unam Sanctam, Boniface, Bishop, servant of the servants of God, for perpetual remembrance,